I should say, on planning appeals in the era of COVID-19. Thank you, Ashley, for the slide. So I'm going to give a short introduction to today's topic. And then following that, Dr. Bose will take us through a point-by-point guide to what we can expect, what we can do, covering the planning inspectorate's position, what we can expect before, during, and after the event, and points to head off now. By way of introduction, I shall touch on a few issues relating to fairness and access to justice in connection both with planning appeals and comparing the position of PINs on the one hand and the courts on the other. Thank you very much for joining us, and thank you also for those of you who sent in questions in advance. We've had quite a number of these, and they're very interesting. So we hope to leave ample time at the end of our discussion to deal with the Q&A. So Ashley, if you could have the next slide, please. Fairness and access to justice, why does it matter? It may seem self-evident that it does matter. It matters both as a matter of principle, since clearly principles of fairness and justice are embedded both in the legal and in the planning systems. I think the point to make here is that so far as all parties are concerned, whether it be solicitors, barristers, the planning inspectorate, and notably the planning inspectorate, there is no suggestion that conducting planning appeals by way of remote technology should be allowed to compromise the issues of fairness and access to justice as we presently enjoy them, or have to date, I should say, perhaps enjoyed them in the old-fashioned way of doing things. In practice, it matters because the planning inspectorate, I have no doubts, will be very concerned to ensure that the system is, to the greatest extent possible, immune from challenge by statutory and non-statutory judicial review. And I am very sure that they will have that at the forefront of their mind as they begin to roll out the various measures in order to accommodate appeals non-physically. So if we could now go on to the next slide, thank you. Striking that in March 2020, around mid-March, two very different approaches were taken by PINs on the one hand and the court service on the other. As I'm sure you'll all be aware, PINs announced an immediate suspension of all planning appeals for the foreseeable future, and made the observation that accommodating appeals by way of remote technology could present difficulties, in particular as regards third parties. At the same time, the courts, the Lord Chief Justice, announced that effectively it would be business, if not quite as usual, but business would carry on in the courts and full use would be made of remote technology for right across the board, whether it's in the planning court, family court, administrative court, and so on and so forth, subject to the caveat that if physical distancing is possible, in-person appearances would be permitted, but only in highly unusual circumstances where it was impossible, for whatever reason, to use remote technology, and it was essential that the appeal or the hearing should go ahead. But note, so far as the courts were concerned, and this is relevant also to the planning inspectorate, the Lord Chief Justice did emphasise that the views of the parties would be a primary consideration in determining how and by what methods a hearing should proceed. And I have every reason to believe that PINs will take a similar approach. And just to note, again, the position of the court in two recent decisions of the Court of Appeal from the Family Court, a similar approach was taken. Exceptional circumstances required for in-person events. So as I say, starkly different contrasting positions, and I think it's an interesting question to ask why. What we learn from the approach of the courts is that, as we can all appreciate, I think, it's perfectly possible to use remote control technology for making submissions, for interaction between the decision maker and the barrister, and so on and so forth. But what the experience from the courts show is that it is possible, perhaps somewhat counterintuitively, it is possible to use remote technology to cross-examine witnesses. And that obviously is a highly pertinent consideration so far as planning inquiries are concerned. And I think what that indicates in very stark terms is that the primary consideration so far as the planning inspectorate is concerned is the role of third parties and enabling them fully to participate in appeal inquiries and appeals by way of remote technology, leaving aside interaction between the lawyers. So with that by way of introduction, I think I will now, I've covered all these grounds. So just to note the response of the lawyers to the PIN's immediate cancellation. The Law Society Committee of the Law Society and the Central City of London Law Society wrote a long, detailed letter, which I shall be drawing on in the Q&A session, setting out a range of very constructive suggestions as to how planning appeals and various other planning matters could proceed in the age of the coronavirus. As I say, I'll come back to those suggestions later on. And similarly, barristers through PIBA and individually have been in touch with PINs, stressing, of obvious relevance to them, stressing that appeals can go ahead in their entirety, including by way of cross-examination. So Ashley, if I could have the next slide. And the emphasis in this connection is on the duty principles, the presumption of fairness. You can see them all set out on the screen. And note the important consideration, which could indeed have been made to suit current circumstances, that standards of fairness are not immutable. Fairness is context specific, and that the key consideration is the statutory scheme, and also the opportunity, giving interested parties the opportunity to make representations and information about the case that they need to answer. And then finally, on the next slide, we can draw from this that representations do not need to be in person to be fair. Remote technology can still ensure fairness, provided that parties are informed of the opposing case and have the opportunity to make representations. Now, Dr. Bowes is going to put some meat on the bones of all of this. And over to you, Ashley, with the planning inspectorate position.
Thank you very much, Lisa. Good afternoon, everybody. Lovely to have you with us. Just a reminder of where we are. So all site visits, in-person hearings and inquiries have been suspended since the 17th of March. It seems an awfully long time ago now. And as of last week, the inspectorate have abandoned Rosewell timescales, so average timescales for determination of appeals from the start letters. That's now gone by the wayside as a consequence of the current situation. However, the inspectorate are keen to keep things moving, and they are keen to explore virtual events. They don't appear yet to have a settled view, although it's useful to know that the internal planning inspectorate platform for their internal meetings is Microsoft Teams. So that might be a useful thing to invest to become familiar with. But public participation really is the single biggest challenge for the planning inspectorate. And that's different to the challenges that's faced by the court service. Obviously, justice needs to be open, doesn't always have to be. Judges have a discretion to have proceedings in private. But in any event, it's not public participation, it's merely public access. And that's well illustrated by the Kendall and Rochford High Court case, which was a challenge to an adoption of a local plan. And in the context of that, the council had advertised its various drafts and amendments of its local plan and its sustainability appraisal by simply its website, hadn't made hard copies available, or only to a very small select group of people, and the High Court found that to be unfair, although ultimately didn't quash the decision because the claimant had nonetheless not been prejudiced. But it does show that planning authorities and the planning inspectorate do face particular challenges for what the inspectorate have now styled the digitally challenged. But what's been happening? Well, there's been, we're told, 1,700 decisions issued since lockdown, although that's probably not the greatest measure of how the inspectorate have adapted, because the vast majority of those would have been determined in the evidence gathered prior to the restrictions coming into place. There have been, however, 13 local plan letters issued. We've had the first appeal determined by way of a virtual site visit. That was a domestic extension in Hastings, so not the most complex of things, but nonetheless shows that they are possible. And I know we've got some questions to deal with that afterwards. And the first digital pilot is taking place on the 11th of May. And again, this isn't an enormous scheme. This is a proposal for an agricultural tied dwelling in Bude in Cornwall, but nonetheless may make history by being the first permission determined after a fully virtual appeal hearing. Slightly interestingly, and perhaps a glimpse into what the inspectorate are doing, and as an explanation as to some of the delay, the inspectorate says it's 3 months before it rolls out good practice about digital hearings widely, and a full 6 months before we have fully digital and hybrid events. And I think this shows us that what the inspectorate are looking to is really more fundamental change, and is using the current restrictions and adaptations that we're having to make to respond to the coronavirus as a platform and a catalyst for getting those things done. And I think that was well illustrated by Graham Stallwood's speech earlier on this week, who's the operations director for the inspectorate, and he talked about single track events, so a public inquiry or a hearing or written reps being probably more a thing of the past, and that what we're going to see is something more like maybe akin to the NSIP regime, where you've got a blend of approaches for complex schemes, some things being dealt with by written reps only, some topics by round table, and then really just reserving those matters which need cross-examination for in-person cross-examination events. And Graham was also keen to emphasise that the inspectorate's very keen to explore and encourage the use of 3D visualisations and augmented reality when determining planning appeals. So I think all of this is about a more fundamental review about how we do planning appeals, rather than simply making the relevant adjustments for the current situation. So I've structured what I'm going to look at as in 3 sections: before the event, during and afterwards, about practical things that we might need to think about when we're preparing for a virtual hearing. What's very likely is there's going to be a need for, like the courts, a single continuously indexed and paginated PDF file of all the essential core documents, and that's going to have to be indexed, paginated throughout in a consistent form, hyperlinked and available online for third parties to interrogate and to engage with. It's probably sensible, knowing where local authorities are with their resources and maybe their access to document building software like PDF Editor Plus and such, that appellants, where possible, try and take the lead in that to avoid unnecessary delay. There may also be a requirement or a need to host some documents on third-party websites, although this, of course, will present its own challenges with the planning inspectorate and local councils to ensure that there's sufficient public trust that those are the appropriate place to access documents. Because if all documents are going to have to be uploaded in PDF form or digital form, there may not be the storage capacity for authorities, and the appellants may want to think carefully about whether they host their own websites to do that. Two important matters which do need to be thought about. Planning authorities are going to have to think about amending their statements of community involvement. Many of those undertake that documents will be available at specified addresses and in hard copy. That is inevitably unlikely to be possible for quite a long time. And so that's something that does need to happen quickly. Statements of community involvement need to be approved by the full council, so that needs to be done by way of a virtual council meeting. But one of the odd anomalies is that the EIA regulations still appear to require that environmental statements are available for inspection at an address. The pipeline regulations, where one might think there was slightly less demand for documents that are going through the pipeline regulations as opposed to the EIA regulations, they have been amended to allow documents to be inspected virtually or documents to be posted. It does seem a rather anomaly that the EIA regulations are still seeming to require hard copies to be available at inspection. So also what can we expect? Well, I think there's going to be a lot more use of topic-specific statements of common ground and Scotch schedules. Of course, all those people who are engaging with the Rosewell inquiries will be well familiar with this now, and I would imagine that this will be a good way of focusing the issues so that a virtual event can run as smoothly as possible and with as minimum disruption as possible. There's highly likely to be the need for more than one telephone conference to get all this in place, even after we relax the current measures. There's likely to be huge restrictions on individuals coming together in large numbers in a single space to observe a public inquiry, and setting all that up, having perhaps a separate room where people can be appropriately distanced from one another, which then links back to the inquiry venue, is all something that needs to be done early on. Those venues need to be booked and needs to be agreed who's going to be bearing the cost of all that at an early stage. So what about during the event? Well, I think roundtable is most likely to be prominent over cross-examination. Cross-examination is challenging at the best of times, but it's going to be especially challenging if there's a delay on the line and pressing questions. So perhaps a hearing style is the most likely easiest way of getting out answers and exploring and getting the appropriate evidence before the inspector over cross-examination. But enforcement appeals are, I think, very likely to be delayed, both because they didn't fall within the Rosewell time limits anyway, so they weren't within the sort of super quick average timescales. And in any event, a lot of them do turn on quite heavily contested disputes of fact, which don't generally lend themselves to a hearing format. So it's probably likely that enforcement appeals are going to be some of the last to get back going again. And therefore, parties, planning authorities really do need to be thinking creatively about how to resolve enforcement disputes. And maybe this is a time where mediation really does have a role, because it can be done quicker. And if the parties are content with an outcome, then it can be formalised by way of a legal agreement, Section 106 agreement, and the planning authority, on receipt of that, may well be then satisfied to withdraw the enforcement notice, all without having to go through an appeal. So that's probably something to start thinking about now, because these are unlikely to be getting on track anytime soon. A topic basis is more likely. There's no set video conferencing platform, but it will need some form of document sharing facility, because inevitably, however well organised the parties are, always new event issues will come up through the inquiry, new documents, and there needs to be a way of third parties being able to access that through a virtual platform. It's important, I'd say essential, that the parties have a secure means of communication during the event, be that through email or WhatsApp. I really would advise against using the in-program messaging services. That's because on a lot of them, Zoom, Teams, a lot of these platforms, the host at the end of each session can see what all the parties, if it's been recorded, can see what the parties have been saying through the messaging function. So even if the host has been copied into that, that is then available for view by the host. So in this case, the planning inspector. So you may not want to have all the smart remarks you've been making about the inspector then available to the case officer and the planning inspectorate later on. As I say, PINs are particularly concerned about the so-called digitally challenged, so people who are not adapting or not able to adapt as quickly to having online video platforms. So what the inspectorate are thinking there is that there may well be a need for having telephone access to inquiries, but also PINs seem to be seeing that there are opportunities for reaching people who would not otherwise have the time or availability to be available during the day because of work or childcare commitments to attend a traditional event, and that having the availability to participate in an inquiry or a hearing virtually may well reach sections of society who would not otherwise engage with the planning system. So challenges and opportunities there. After the event, well, site visits likely to be unaccompanied for quite some time where possible, and this really means that your key witnesses, be they probably your landscape heritage witnesses, are going to need to think very early about an agreed route, so that can then be shared probably through the planning authority's website with third parties, so that that can all be given in an agreed form to the inspector before the virtual event closes. Just a quick set of issues to think about now. We're coming into the late spring and early summer, when a lot of surveys are required for a lot of particular species, provided that risk assessments are done to enable that the people undertaking the surveys are kept safe and not at risk of contracting coronavirus. For example, perhaps avoiding public transport and being able to access sites without other people being there. Even under the current restrictions, which may look as though they're being eased over the next few weeks, but even under the current measures, travelling for the purposes of work where it's not reasonably practical to do that from home is a reasonable excuse for being outside the house. So surveys probably can go ahead. And that's all confirmed in the Natural England guidance that was issued in the last fortnight. That emphasised that they'll be as flexible as they can, but really that the legal constraints on decision makers mean that you can't skip surveys and you can't grant permission without having at least a pretty good idea about the extent of protected species that might be on site and the extent that they may be affected by development. And the more alert amongst our audience will remember the Bagshaw case, which was where a local authority granted permission in the absence of a survey, but subject to a Grampian condition one was carried out afterwards, and that was quashed for want of having regard to a material consideration beforehand. So the key really is to make sure that these things aren't delayed, because if we all do start getting back to normal again and the surveys haven't been done in the relevant window, then there may be a very extensive delay before the next survey season arises. So that's something to think about now. Perhaps more simply, invest in document building software, so something like PDF Editor Plus or its associated programs, which enable you to merge multiple PDF documents into one continuous format and then paginate them and hyperlink them. And think about the protocols that should apply around hosting websites with a local planning authority. So as I said, building public trust that these websites are the appropriate and official way to access information about a proposed development will need signposting by the local authority on their website so that the public have confidence that that's the accurate information. So with that, I'll turn to Lisa before we then, to wrap things up, before we then turn to addressing some of your questions. Thank you.
Thank you very much, Ashley. Yes, by way of concluding thoughts, I think the point that I wanted to make is one that you just touched on yourself, which is, if I may put it this way, accentuate the positive. I mean, PINS is obviously entirely understandable that they are concerned about the digitally challenged so far as third-party members of the public are concerned. There are quite a few others of us who are digitally challenged. And it's a bit of a learning curve for very many people, I think. And just so far as that is concerned, there was quite an interesting little article published very recently in the Local Government Lawyer by an officer of Kensington and Chelsea London Borough Council, reporting back, as it were, on their first ever entirely virtual planning committee meeting. And he said, by and large, it went smoothly, but he did emphasize that members and officers really had to work quite hard to come up to speed, to familiarize themselves with the technology and make sure that the technology could be adapted in the ways that were necessary. And the end result was that it worked smoothly. 2 points, I think, to note. One, he said they had 4 or 5 IT officers constantly monitoring the proceedings so that one or more of them could step in at any point. And that may be something that will be necessary so far as planning appeal hearings are concerned, and indeed inquiries. And secondly, at least in that instance, the virtual meeting was attended by 5 members, that is to say attended virtually, with some 200 members of the public listening in. And interesting for local authorities to note that officers in that instance did offer to provide bespoke assistance to members of the public who were, to use the term, digitally challenged. which seems to have been very well received. So, I mean, the point that I think I would make more generally for local authorities is that they are obviously used to playing a facilitating role in physical planning inquiries and hearings, whether it's simply a matter of organising the forum, providing tea and coffee, distributing papers, and making sure, playing to a greater or lesser degree a role in ensuring that members of the public understand what's going on, what the procedures are, and so on and so forth. And I anticipate that that role will continue and indeed be reinforced in the new ways of doing things, at the very least as they're being rolled out. But to look on the bright side, I agree with what you say, Ashley, that I think in the long run, at least, it may be that in fact the use of digital remote technology will serve to in fact facilitate access to justice. As you say, with people who don't require to take a whole day off work in order to attend an inquiry, people who have mobility issues, and so on and so forth. And indeed for lawyers as well. As we all know, there are issues about childcare being compatible with going on a long planning inquiry far from home. If at least some of that activity can be undertaken digitally, then that obviously is a benefit as well. So I think we have some reasons to be cheerful. It's going to be challenging for many people, but I think really in the end, possibly at least, quite a positive experience. So we're now going to deal with the Q&A session, and as I say, we had a number of very interesting questions put to us. One of them concerned site visits, and actually I think you've already dealt with that really. Just to note, as I agree with you, that it's important to have regard to Regulation 6 of the regulations regarding the need for a reasonable excuse in order to leave home in connection with work. Plainly, an inspector will have a reasonable excuse to do so for the purposes of a site visit. We know that there's a trial of virtual site visits underway involving 13 inspectors, so we will have to obviously await the outcome of that. But all the indicators are that PINS is keen one way or another to ensure that site visits continue. And again, it may be a combination depending on the circumstances of physical and virtual. And I know from the experience that I had working on High Speed 2, for example, that the virtual technology, the 3D visualizations can be absolutely extraordinary. And what one would think not of such nature as to compromise what can be gleaned by an inspector on his or her site visit. So I don't think there's a great deal more to be said about that. Ashley, would you like to deal with the next question?
Yes, there's an interesting question from Tracy Smith from South Oxfordshire, and her question is about advice for planning authorities and everyone really about how we go about counting housing land supply and the consequences of the impact on development that the current restrictions might have had. Well, I suppose there's 3 points in response to your question, Tracy. First, for the sites with full planning permission and minor development that has outline planning permission, the presumption is that the site will come forward within the lifetime of the permission unless there's clear evidence to the contrary. So I suspect those ones are less likely to be problematic. It probably then mainly is the outline schemes which are not minor development, and therefore the planning authority needs to show clear evidence that they will come forward within the relevant time frame of the permission. And really how MHCLG will deal with this is one of 2 ways. Either they will see house building as a key to staving off or recovering from any economic consequences of COVID, and therefore they'll see it as not a wholly bad thing that a number of authorities will fall below the relevant 5-year threshold, and therefore there'll be more development going on. Or they'll take the other view, which is that they don't want, as a short-term unforeseen situation, to then give license to unsustainable development and undermine public confidence in the planning system. So I think we're watching and waiting to see what Robert Jenrick and his team have to say and which way they'll go, whether there'll be more sort of Treasury influenced, or they'll be more influenced by the Tory shires as to what guidance that they will make as to how inspectors should go about counting and assessing land supply. I'm sure inspectors will be very sympathetic, but it's what they then make of that in the planning balance that will be the issue. And we're still really waiting to see what MHCLG have to say about that. Thank you for your question.
Thank you, Ashley. And then next we again had a number of questions concerning the likelihood of the temporary changes to permitted development rights being extended or made permanent. This was a matter that was dealt with at some length by the letter that I referred to, the letter of the 15th of April from the Law Society for England and Wales and the City of London Law Society. They were very keen to see an extension of the PD rights in question until at least 2021, if not made permanent. Obviously, the approach that the government will take here depends to some extent on what actually happens with COVID-19. The Law Society has made a further suggestion, which is that the National Planning Policy Guidance could be amended to include issues arising from COVID-19 as material considerations when assessing the proportionality and expedience of taking enforcement action, subject to a proviso that there could be overriding considerations such as impact on amenity and so on and so forth. So for example, the permitted development rights concerning the use for restaurant facilities and others for hot meal takeaways. Obviously, that could be subject to amenity considerations as is reflected in the regulations. And then, so far as emergency development is concerned, the powers on local authorities and health authorities to take steps to deal with immediate threats to human health, those changes currently expire on the 31st of December 2020, and the suggestion of the Law Society is that they should be extended to the 23rd of March 2021. We've seen that the government and the Secretary of State is prepared to be flexible and reactive to the problems that COVID-19 is throwing up. So I would anticipate that if there is a need for an extension of permitted development rights, then that will be implemented. So thanks again for that question as well, and over to you, Ashley.
Thank you, Lisa. I suppose just the only thing to add to that is that the government's early response to all of this, certainly when there was a lot of panic buying of certain grocery products and other things, was to issue a ministerial statement asking planning authorities to think carefully before taking enforcement action about deliveries. And that really was all about ensuring the security of the supply chain. And now that seems to have stabilised and is likely not to be imperiled in the coming months. I suspect that kind of guidance will be rolled back. But as Lisa says, the PD restrictions, the PD tolerations may well be in place for a bit longer. There's a question from Derek Lawrence, who's asked whether planning permission will be extended. Well, one of the great peculiarities, and it presumably a deliberate anomaly because it's been drawn to the government's attention a few times, is that the Scottish government's coronavirus legislation allowed planning permissions to be extended, whereas the English legislation didn't, and the ability to extend a time limit is still prohibited. So unless a planning permission is implemented within the relevant time, it will lapse, irrespective of the fact that people might not have been able to get on site, they may not have been able to access material. So certainly there isn't any discretion on the part of a local planning authority if they weren't satisfied that a permission had been lawfully implemented within the relevant time. The permission will lapse, and they don't have the ability, as in Scotland, to permit extensions at the moment. Thank you.
Right, thanks again, Ashley. So next, a number of people were concerned to know our views, at least, as to whether two related issues, I suppose. First of all, whether virtual hearings would be appropriate in circumstances where members of the public in particular had no access to the internet. And secondly, whether or not there's a likelihood of virtual hearings being made compulsory at some time in the future. As to that, as Ashley's already mentioned, the Planning Inspectorate shares the concern, obviously, about lack of access to digital technology, and is mooting the possibility of telephone technology being used, as well as, or indeed instead of, virtual video conferencing. Plainly, I think I mentioned that even in the case of the courts, which arguably embraced the use of remote technology rather more enthusiastically and quickly than PINs, that there remains an overriding consideration that all relevant people participating should have access to the technology concerned. And there's always a caveat, I suppose, which is that if, for whatever reason, a relevant person does not, then that might be a situation, however unusual, in which the hearing will have to take place physically. As I said, there may be a role, subject no doubt to resources and related considerations. There may be a role for local authorities to assist members of the public gaining access to the relevant technology. I mean, an obvious consideration in days gone by would have been provision in libraries for public use of computers. Plainly, that's not going to assist now, given that libraries are all closed. But that, again, as time moves on, there may be ways and means for local authorities to assist in that connection. As to the question of whether it's likely that virtual hearings will be rendered compulsory, well, for the same reasons, I suspect the answer is no. But I think it's highly likely, at least in the immediate to midterm future, that they will be the default position for, certainly for everything that can conveniently be done by way of remote hearings, so notably planning hearings, roundtable sessions of inquiries, and so on and so forth. But I very much doubt that they'll be made compulsory because, as I say, they'll always be subject to the consideration that fairness and access to justice requires to be maintained. So Ashley, on to you.
Thank you very much, Lisa. My final question is from Mike Pocock from Pinson's, and he says, well, can ordinary planning appeals, Section 78 planning appeals, learn something from the NSIP process, which develops more a written reps basis and then targeted hearings? Well, yes, and I think the Planning Inspectorate, as I said, see the current crisis as very much a conduit to moving to a system that's more like the NSIP process. It won't be appropriate in every instance. As I said, enforcement appeals require detailed factual cross-examination, which doesn't arise on an NSIP appeal, or indeed a Section 78 appeal with the nuanced planning policy argument. So there'll still need to be a role and place for traditional in-person cross-examination inquiries. But I think the days of having a standard Section 78 appeal where everything is dealt with by way of cross-examination and formal submissions are probably numbered, and we will move towards a system of a more blended approach that's probably more proportionate about people's time and being in the same room at the same time, and using virtual platforms to perhaps facilitate some hearings on some more minor topics, dealing a lot more with written reps on issues around planning policy, and leaving cross-examination just for sort of the critical judgment issues that need to be explored, either because they're very complex or they need to be thrashed out in person for an in-person event. So yes, I think you're absolutely right about that. Just to say to Kevin Goodwin, who's a very interesting question about parking stress, I'm not quite following what the nub of that question is, and what I'd say to him is if you could just email one of the people below on the slide there with that query, then we'd be happy to get back to him, or certainly I'll be very happy to get back to him outside this session, if that's all right. Thank you. Thanks,
Ashley. And a related question, which I thought was very interesting, was the question of when should advocates insist on cross-examination? And in a sense, to some extent, we've got experience of dealing with that in the wake of the Rosewell review, since obviously, as you all know, inspectors have a discretion as to whether or not various matters should be dealt with by way of a roundtable session on the one hand or cross-examination on the other. I have to say, in my experience, the approach that's been taken hasn't been entirely consistent. I've had some inquiries in which matters relating to transport has been, without question, as it were, allocated for a roundtable hearing, and others in which it was without question allocated for cross-examination. But it's fair to say that it will depend very much on a case-by-case basis, and obviously a case can be made by counsel or the local authority or developer client on his or her behalf, as the case might be, insisting that cross-examination is necessary, maybe because of the familiar considerations, the complexity of the issues, the importance of the issues at stake, in the degree of interest amongst members of the public. And once again, I mean, I must say, when I began my talk with referring to the importance of fairness, I thought I was sort of stating the obvious, which indeed I was, but I do find myself coming back to it time and time again. And I think, so far as the question of when can advocates insist on cross-examination is concerned, it does yet again come back to considerations of fairness, which, as I say, I'm confident that the Planning Inspectorate will be very minded and keen to protect. And if a case can be made by counsel that his or her client's case is liable to be prejudiced if cross-examination cannot take place, then that clearly is a matter to which the inspector dealing with the matter will give very, very considerable weight. And indeed, just to hark back again to the procedures we're all familiar with, of course, again, a case quite often has to be made as to whether or not how should be dealt with in the first place, whether by written reps, a hearing, or an inquiry. So again, I think similar considerations are likely to arise in the current circumstances when the need for cross-examination arises. And as I indicated right at the outset, I know that cross-examination is taking place by way of remote technology in the courts. Speaking for myself, it will be something new to get used to, and obviously it's something that probably can and will be made to work. But I think we probably all agree that cross-examination in person is preferable. So one would hope that will continue into the future, subject, of course, to appropriate safeguarding measures. And as Ashley says, we're highly unlikely to see what the situation we've had to date of large numbers of people in a single room. But of course, cross-examination could take place with relatively few people being in a relatively large auditorium, with members of the public listening in virtually. So yes, I think there is a role for advocates insisting on cross-examination being required, and I expect that Council's views in that regard will be taken seriously. So that is all the questions that we were going to deal with in advance, and I'm looking at the question and answer session. What we have is some answers to a question that I raised right at the beginning of this session, which is, can you hear me? To which so a number of people very helpfully replied yes, so thank you for that. We do have one question from Kevin Goodwin, which is, on a recent virtual pre-app, the council advised that they weren't accepting parking stress surveys, so unless we provided full parking numbers, the application couldn't be submitted. Any thoughts? Well, that does relate to an issue which I think is likely to arise in a number of cases concerning the difficulties associated with going out physically and obtaining the evidence that is required in order to substantiate a case, or indeed a planning application at the application stage. It's a good question. Actually, I don't know if you have any views about this particular matter. I mean, I think one would hope that local planning authorities would exhibit a degree of flexibility in order to enable the planning system to continue in circumstances in which we are subject to physical restrictions.
Yes, I think, as I indicated a bit earlier, that I'd need to know a bit more about that, and I'd ask Kevin if you like any more information, just to drop me or the clerks an email. But as you say, Lisa, really it shouldn't be a barrier to validation, especially at the moment, because you're not liable to be able to get an accurate figure, or indeed potentially be able to even go out in order to do that properly. So my immediate reaction would be planning authority really should accept the documents as they are, and perhaps with a caveat that they're then perfected at a later date.
Right, well, thank you very much, everybody. I think we've come to, we're just on 14:47 by my clock, so we're bang on time. I hope that you found that interesting and helpful. Obviously, it's a bit of a learning curve for all of us, and an ongoing one. Personally, I think Ashley's tips were very, very helpful indeed as a way of getting us started. You will also find a number of other webinars on related topics, planning topics, on the Cornerstone Barristers website. As you'll have seen from the beginning, this webinar will be available shortly on the website. So please feel free to avail yourself of those webinars and the other resources which are available to you there. Thank you very, very, very much for joining us.